Good morning, good morning, good morning, and welcome back. Welcome to Sunrise right here on CVM. Wherever you are in the world, we're there with you too. Good morning to Sandy Solid and everybody in New York watching, and of course to all our YouTubers. Do remember to hit the like button, hit the subscribe button, and always do remember to spread the word. It's that time of the morning for Law and Order JA, and this morning I'm joined by attorney at law Toni Smith. She's here to offer some counsel on your issues. Good morning, Toni Ann. How are you?
Good morning. I'm doing quite well, and thank you so much for having me.
Beautiful. All right. So the question that was submitted to us reads as follows. My HR manager receives a call from an employee's spouse requesting that the employee's compensation history can be shared. Now, can the HR manager share this information with the employee's spouse, or is that totally off limits?
Well, that is totally off limits, and it is because of a little thing called the Data Protection Act.
Yes.
So the employee's compensation history would constitute personal information or personal data. And as the personal data is something that should be retained with confidence. So of course, the data subject in this case, which would be the employee, should consent for any information such as that to be shared in any manner. So of course, it would not be permissible under those circumstances.
But counsel, I can just see the spouse saying, but we are married, we are together, we are one.
Right. And
we're, you know, what is his is mine, or what is hers is mine. And I need to know because it is important.
Right. Well, again, as I would have alluded to previously, as much as the union, they're one, them get married, everybody come and sing praises at the wedding, the idea is that it is still personal to that spouse. And of course, it constitutes information that is related to that employment, not even in relation to the marriage.
Right.
So again, the idea with data protection and the Data Protection Act is to ensure that information that is personal to you, even you, Miss Kitty, that it remains only to you. And if it is that you want someone else to know it, they would have to authorize it. Absolutely, you have to authorize it. So it doesn't matter if it is a union, such as a marriage, or even if it's a case where you personally had experiences with that person has a right to state that they want the information to be shared.
What if it, let me give you another hypothesis. Right. What if it wasn't a spouse but a mother? So, but is my child, is me bring her come in the world, or me bring him come in the world, and I want to know some information from the HR manager? Not even a parent could get that information?
No, under those circumstances, not even a parent. But of course, there will be exceptions, for instance, in a medical setting. Yeah. As immediately when we think about children, we think about a medical setting, like with a healthcare situation, for instance. Yes. Wherein the parent would have rights because up to the age of 18 or the age of majority, of course, then if the parent consented, then that would be sufficient. Right. But certainly in this case, if it goes back to the same compensation history, it would have to be that person themselves that gives that allowance, authorization. And the idea is, as many Jamaicans can relate to keeping personal information safe, this whole thing started with the passage of the NIDS.
Yes.
Right?
Yes.
And so the idea is that Jamaicans, as many people out there would have felt uncomfortable thinking that their information could be used in a way that would be unauthorized by them, right? They want to ensure that we can feel safe, that our information is out there, it is protected. And that was the idea, that was the legislative response of the government to pass the Data Protection Act, to say that it is not that we cannot use person's personal information, it's not that it can't be divulged, but there must be safeguards that are put in place that would govern that.
And of course, let me ask this now, counsel, what if the HR manager did not know about the Data Protection Act, was not so aware of the consequences?
Right.
What could flow
absolutely
from
excellent question
exposing such information? Because some people just think, you know, they can expose their information without any kind of consequence.
Right.
What kind of consequences flow from revealing such?
Well, firstly, as you would know, ignorance of the law is no excuse. So that's not going to save the manager. But of course, the Act speaks to sanctions. And in a case such as that, the organization, because the HR manager would be in an organization, they could face sanctions. We have, I call it the police of data protection, which is the Information Commission, or the Office of the Information Commissioner. So we have the Commissioner of Police, we have the Commissioner of Data Protection, and they can sanction that organization for fines up to 4% of their revenue. Wow. And also the officers, so the HR manager in question and other senior officers in the corporation or the organization could face imprisonment if it is that the commissioner so finds to send it to the DPP for prosecution, right? So it's some serious sanctions we're talking about.
So if it was blatant disregard,
absolutely,
and it was so egregious, then
absolutely, then they could find the responsible persons actually facing imprisonment.
Let me ask you also, Consa, because you're bright and you graduate,
like you, right?
What about a power of attorney, POA, power of attorney? What if somebody has a power of attorney and they are requesting this information? As you know, power of attorney allows the individual to step in the shoe of the person.
Yes.
So if I have a power of attorney and I want to find out some information about my spouse's, compensation plan and all of that, does the POA allow for that, or still the Data Protection Act protects the individual?
All right. Well, that's a really good question. And the idea is that, as you said in the last part, the Data Protection Act would still protect that information. But it is, again, not a wholesale bar on that divulging of the information. It just means that, in this case, instead of asking the data subject, as the Act would say, the person to whom the information relates directly, instead of asking that person, because a power of attorney was in effect, then the permission would have to be granted from the PO, the person acting with the power. So, again, it goes back to ensuring that your information remains personal to you, and the idea behind this, again, going back to the needs, it really started from the pronouncement of what we call the right to informational privacy. So that is what the Constitutional Court in Jamaica found, that we, citizens of this country, have a right to informational privacy, which is that we have a right to keep any information that is personal to us safe and secure, and we now determine how that information can be used.
And companies that have that kind of information, they have a duty to protect that information, and if you don't, then there are consequences.
Absolutely.
So Counsel, finally, let me just ask you in closing, if somebody's information protection is violated, or the protection of that person's information is violated, what legal steps can they take to seek a remedy?
Okay, well, firstly, as again, going back to the Police of Data Protection, I would recommend that, one, they can file a complaint with the Office of the Information Commissioner. And of course, that complaint would be against whichever organization would have mismanaged that person's information. Of course, there can also be cases where, again, the case will be taken under the criminal jurisdiction, where sanctions could now actually be imprisonment, fines, imprisonment could be held against the officers in question. But I believe that the first step would have to be ensuring that there's a complaint that is filed. And even before that, if it's a case where you want a more amicable resolution, for instance, you can actually bring it to that organization, bring it under their internal disciplinary measures, and provided that that fails, for instance, then certainly the Office of the Information Commissioner. But because it is an express right that we have to defend our right to informational privacy, I would say definitely ensuring that you make that report with the Office of the Information Commissioner.
Very well articulated, Counsel. Thank you so very much.
You're most welcome.
This is Attorney at Law, Tony Ann Smith. And please remember to keep those legal questions coming by sending them to our socials at CVM_television or at Sunrise CVM. We'll be right back. Stay tuned.